It turns out the United States Constitution may save us from another Trump administration. I'm going to explain to you what I mean in just a second. Hello, everybody. I am Attorney Augustus Corbett, a.k.a. the Minister of Justice. I'm one half of the Defiant Lawyers. Each and every week, we bring you at least one legal analysis of trending politics, policies, personalities, or pop culture to empower you with the information you need to defy an unjust legal system. Please subscribe if you have not, like, share, and comment on today's video and on the rest of the videos. Well, yes, as I said in the opener, the United States Constitution very well may save us from another Trump administration. It turns out Section 3 of the 14th Amendment has language that specifically bears on Trump becoming president again. So let's get right into this. Now, before we look at that specific language, what I want to do is I want to introduce the authors of a law review article as well as a recent article in the Atlantic magazine. All of these authors, by the way, are conservative, Republican. 3 of the 4 are members of the Federalist Society. If you don't know what the Federalist Society is, trust me, it is not a liberal organization. It is an organization that oftentimes recommend the justices who are going to sit on the Supreme Court when it's the GOP's turn to nominate someone. In other words, it's a very conservative organization. And of the 4 authors that I'm going to talk about today, at least 3 of them, I believe the 4th is as well, but at least 3 of them are absolute members of the Federalist Society. So let me introduce you to the authors of a law review article and, again, an article in the Atlantic magazine. All right, let's go and meet these authors. So the first guy is Professor William Bod. I think that's how his name is pronounced. William Bod is a professor of law at the University of Chicago Law School, where he teaches federal courts and constitutional law. His current research papers include adjudication outside Article 3 and constitutional liquidation. He is also the co-editor of the textbook, The Constitution of the United States. He is also an affiliated scholar at the Center for the Study of Constitutional Originalism and a member of the American Law Institute, where he has advised on the 3rd restatement of the Conflict of Laws, and an occasional blogger at the Volokh Conspiracy. He received his BS in mathematics from the University of Chicago and his JD from Yale Law School. So he seems to be an intelligent guy. He then clerked for then Judge Michael McConnell on the United States Court of Appeals and Chief Justice John Roberts. So he is a true conservative on the United States Supreme Court. Before joining the Chicago faculty, he was a fellow at the Stanford Constitutional Law Center and a lawyer at Robbins Russell LLP in Washington, D.C. So Professor Bod is, again, a bona fide conservative Republican, most likely. Okay, his co-author of this law review article, his name is Michael Stokes Paulson, and he is a distinguished university chair and professor of law at the University of St. Thomas, where he has taught since 2007. Professor Paulson is a graduate of Northwestern University, Yale Law School, and Yale Divinity School. He has served as a federal prosecutor, as an attorney advisor in the Office of Legal Counsel of the U.S. Department of Justice, and as a counsel for the Center for Law and Religious Freedom. So Professor Paulson and Professor Bard are the two authors of a law review article that makes a very strong argument that Donald Trump cannot be president again. They are definitely members of the Federalist Society. They are very conservative. So it's not me who is saying that the Constitution can keep Donald Trump from being president again. It is people within his tribe who are saying that. So don't take my word for it. These are folks who agree with him probably on a whole lot of things, okay? But it doesn't stop there. The authors of the Atlantic article, one is Professor Lawrence Tribe. Lawrence Tribe, the Carl M. Loeb University professor and professor of con law at Harvard, has taught at its law school since 1968. Wow. And was voted the best professor by the graduating class of 2000. The title university professor is Harvard's highest academic honor, awarded to just a handful of professors at any given time and to just 68 professors in all of Harvard University's history. Born in China to Russian Jewish parents, Tribe entered Harvard in 1958 at 16 years old. Smart guy. Graduated summa cum laude in mathematics and magna cum laude in law, and clerked for the California and U.S. Supreme Courts and received tenure at 30 years old. So Professor Tribe is a smart dude. He's also a member of the Federalist Society, which therefore means he's definitely conservative, okay? Last is a former federal judge, Judge J. Michael Luddick. He served on the U.S. Court of Appeals for the Fourth Circuit for 18 years, from 1991 to 2006. He's currently counselor and special advisor to the Coca-Cola Company and its board of directors. Prior to joining the Coca-Cola Company, Judge Luddick was counselor and senior advisor to the Boeing Company and board of directors. He was executive vice president and general counsel of Boeing from 06 to 20. Before he was appointed to the federal bench by President George H. Bush, he served as assistant attorney general at the U.S. Department of Justice and counselor to the Attorney General of the United States. He was assistant counsel to the president at the White House from 1991, or was that 81? 1981 to 1982 under President Ronald Reagan. From 1982 to 1983, he was a law clerk to then Judge Anton Scalia. Again, these are very conservative people. Of the U.S. Court of Appeals for the District of Columbia Circuit from 1983 to 85, he served as a law clerk and then special assistant to the Chief Justice of the United States. Judge Luddick earned his Bachelor of Arts degree from Washington and Lee University and his law degree from the University of Virginia. So once again, these distinguished scholars and former judge and current professors are very smart folks. They are constitutional law experts, and they are very conservative. They are, again, presumably Republicans. They certainly support the Republican Party, having served or clerked for known conservative judges, justices, presidents, attorney generals, etc. These are the people who are making the argument that a specific provision of the United States Constitution prohibits Donald Trump from becoming president again. It's not coming from me. And by the way, let's be real clear about something. I am not a Democrat, nor am I a Republican. I have been both. I was a Democrat for the first 20-something years of my life, and then I became a Republican. I was a Republican for the next 20 years of my life, And for the last 20 years of my life, I am a political independent. Okay? And I basically think both parties suck at different things, quite frankly. Some things I like that the Republican Party stands for, and some things I like that the Democrat Party stands for. Other than that, I tend to, again, believe that both parties suck with the capital S. So I'm not a partisan. I am not a partisan at all. But I do not want to see Donald Trump in the White House again, because I agree with Judge Michael Ludick, who said that Donald Trump is a clear and present danger to the United States of America. That is obvious, unless you have some sort of bent, some kind of cultic allegiance to this man. Otherwise, clear thinking folks are able to see that Donald Trump is definitely a clear and present danger to the United States of America, to our constitutional republic. And I join as an attorney, as a citizen of the United States of America, I join with these conservative scholars in asserting that the United States Constitution prohibits Donald Trump from becoming president again. Now, with that said, let's begin to look at why I'm saying that and why they're saying that. Let me pull up first what section of the Constitution I'm actually referring to here. So, this is Section 3 of the 14th Amendment. And let me just say, the 14th Amendment is very dear to me as an African American. The 14th Amendment is what gave African Americans citizenship, due process rights, and equal protection under the law. It was added to the Constitution during Reconstruction, after the Civil War, after slavery had been abolished by the 13th Amendment. It is extremely important to the African American community. And this section also sort of deals with the aftermath of the Civil War, but it also applies to today's situation, political situation, and I will explain. So if we read this, it says, no person shall be a senator or representative in Congress or elector of president and vice president, or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. In layman's terms, here's what you just read. This is my paraphrase. If a person served in office as a senator, as a congressperson, as an elector, or held any office under the United States or under any state, and as a part of taking office, they pledged allegiance to support the Constitution, and then subsequently to that, they participate in, lead in insurrection, or provide aid and comfort to those who were a part of an insurrection or rebellion against the Constitution, that person cannot serve as president, as senator, as Congress, etc. That fits Donald Trump perfectly. Perfectly. He was elected president. He pledged allegiance to support the U.S. Constitution. But then he turned around and led an insurrection. He inspired an insurrection against our country and in defiance of the Constitution. So this section says he can no longer hold any sort of office, particularly as president, as the commander-in-chief. So this applies to him perfectly. Perfectly. Now, let me go back. I want to break it down a little bit more. All right, because we're going to have a lot of naysayers who are going to strongly disagree with the professors and the former judge, myself and others who agree with the fact that this particular section of the 14th Amendment definitely should keep Trump out of office. We're talking about someone who has over 90 different charges against him, about 4 or 5 indictments. Some of those charges include leading the January 6th insurrection. All right, so that fits perfectly within the language of this section of the 14th Amendment. Let's go back here. So I broke that section down and I underlined the parts of this section that applies to former President Trump. It says no person shall be a senator or representative in Congress or elector or president and vice president or hold any office, civil or military, under the United States. In other words, hold any office under the United States. That would include the president. All right. No person shall hold any office under the United States of America who, all right, if they meet this condition, who having previously taken an oath. He did that when he became president, not as a member of Congress, but as an officer of the United States. That is, again, being the commander-in-chief. In essence, the chief executive officer, the president. And to support the Constitution, in other words, he took an oath to support the Constitution, which includes the peaceful transfer of power, rather than leading an insurrection to stop the peaceful transfer of power. And so every time Mr. Trump gets on the campaign trail and declares that he won the election, that the election was stolen from him, despite the many courts, including some judges who he appointed, he nominated, who all said that the election was not stolen from him, that is a big lie. I mean, look at the state of Georgia, a red state. The governor is a Republican, the Secretary of State a Republican. I mean, those folks are Republicans in the state of Georgia, and they all say that Trump lied about their state, and now he's being prosecuted for it. And that's true across the country. So there's no question that he engaged in insurrection. I mean, we all saw him give the speech. We all saw him tell those people they got to be strong or they're going to lose their country. And those folks interpreted that and everything else that he had said leading up to that day as go storm the Congress and stop them from transferring over to Joe Biden the presidency. And we also saw and heard how he inspired those folks to even want to kill Mike Pence, his vice president. We saw and heard this with our own eyes. And so many people were like, isn't there anything that can be done to stop such a person who has done this to our country from becoming president again? Well, here is the answer. The Constitution has the answer. And let's think about it. Here's why this was added to the Constitution in the first place. Because during the Civil War, you had those southern states who basically went to war against the United States. They led basically an insurrection, a rebellion. And so the Congress said those people should not now be able to become the president or serve in any way, since they pledged an oath to the Constitution and then turn around and led an insurrection or rebellion against it. Those people should not be allowed to become the president or senators, congresspeople, and so forth. So that was the reason this was added in the first place. And here we are, a century and a half later, confronted with the same situation by Trump. All right, so that's why it was added again in the first place. Now, let's go now to look at some provisions, some parts of the law review article. Okay, let me pull that up. All right, it's right here. And here is the assessment of the professors who wrote the law article, Professor Paulson and Professor Bond. Here's what they said. I highlighted it. They said, fast forward a century and a half. The events surrounding efforts to overturn the result of the presidential election of 2020 have sparked renewed scholarly, judicial, and political interest in Section 3 of the 14th Amendment. Watch this now. Listen. The core events are familiar to all. The dishonest attempts to set aside valid state election results with false claims of voter fraud. These are Federalist Society members. These are conservatives. These folks ordinarily would be supporters of Donald Trump, but even they call his claims of voter fraud false. And they said his attempts to overthrow the election or to prevent the peaceful transfer of power was dishonest, they said. The efforts to have the vice president unconstitutionally claim a power to refuse to count electoral votes certified and submitted by several states, again, including red states. The efforts of members of Congress, even some members of Congress, Ted Cruz, senator here in Texas, I hope he get voted out, I really do, to assert a similar power to reject votes lawfully cast votes by electors, the fomenting and immediate incitement of a mob to attempt to forcibly prevent Congress's and the vice president's counting of such lawfully cast votes, all in an attempt to prevent the defeated incumbent president, Donald Trump, from losing power in accordance with the Constitution. They called him defeated, a defeated incumbent president. They're mincing no words. And again, these are not Democrats saying this. These are not liberals. These are not progressives. These are conservatives. These are Republicans. They are lifelong members of the Federalist Society of the GOP. This is their assessment of Trump's claims that there was voter fraud. We all know it's a lie, yet he keeps pushing it. And because he's pushing it, he is, again, just a clear and present danger to our country, because he has tens and tens of millions of people who are buying into his lies and who stormed the Capitol, and God knows are willing to do so many other things if he is not declared president in 2024. I mean, that is a person who is a danger to our republic, point blank. So they go on to say this was undoubtedly a serious assault on the American Constitution. Order. Not since the Civil War has there been so serious a threat to the foundations of the American constitutional republic. It takes little imagination to describe the efforts to maintain Trump in office, notwithstanding his defeat as an attempted political coup d'etat. Look at that. They call what he did and what they did, those folks who participated in the January 6, 2020 insurrection, These conservatives called it a coup. These actions culminated in the incitement and execution of a violent uprising at the Capitol on January 6, 2021. Pardon me, I said 2020. January 6, 2021, after the election. Pardon me. An insurrection aimed at preventing Congress and the incumbent vice president from performing their constitutional responsibilities to count the votes for president and vice president in the 2020 election. Several of the people involved in these events, most notably the defeated president, Donald Trump, had previously taken oaths to support the Constitution. If they engaged in or gave aid and or comfort to an insurrection against the constitutional government, Section 3 would appear to bar them from holding office again. This is what they said. Don't take my word for it. For those of you who strongly disagree, who are GOP, who are part of MAGA, who are Republican, who are conservative, these are the scholars of your movement who are telling it like it is. All right? They're telling it like it is. And by the way, I know why they're telling it like it is. Because they are afraid that Donald Trump will cause them to lose against Joe Biden in 2024. So they really just want him to step aside. So they are bringing the pressure so that a Ron DeSantis or a Vivek Ramaswamy, I may have mispronounced his name, or Tim Scott or somebody like that, who basically believe in the same policies of Trump, but they're not as, toxic as Trump. So these scholars, they want Trump out so that there is a chance of beating Joe Biden in 2024. So, I know that. I'm not naive. But anyway, they go on to say here, they defend their position in 4 sections that I want to briefly cover, because there are folks who are part of the Republican Party, who are even members of the Federalist Society, who are conservative, GOP, who disagree with this, who still want to see Trump in office, or they don't have the courage to stand up against him because he has such influence, almost sort of a cultic influence over the GOP. But the first thing that they wanted to bring out here against the naysayers is that Section 3 remains legally operative. So they say it is no less part of the Constitution than the other provisions of the 14th Amendment. It is not a dead letter. The Constitution is a binding, authoritative written text, not a collection of specific historical purposes and intentions. Where the text applies, it applies. Its legal force is not limited to the immediate problem or purpose that prompted this enactment. In other words, it's not relegated to just the events following the Civil War, just like the other parts of the 14th Amendment are not. Our equal protection rights did not end after the Civil War or shortly after it. Our due process and citizenship rights didn't end. They were not, as they said, they were not limited to the immediate problem or purpose that prompted the enactment of the 14th Amendment. So this part of the 14th Amendment is not limited to the immediate problem or purpose that prompted its enactment. The second section, something else that they feel is necessary to defend their position. Section 3 is legally self-executing. That is, Section 3's disqualification is constitutionally automatic whenever its terms are satisfied. This is important because there are some who would argue that Section 3 does not kick in until and unless Trump goes to trial and is found guilty by a jury, or that he pleads guilty, which would never happen. They're saying, no, Section 3 of the 14th Amendment does not depend upon a jury trial, a guilty verdict. It is self-executing. Once those conditions that we talked about, someone who held office, who pledged to uphold the Constitution, then participates in an insurrection or rebellion, once that's met, then Section 3 kicks in and prohibits that person from becoming president. Section 3 requires no legislation or adjudication to be legally effective, so Congress doesn't have to do anything and a court doesn't have to do anything. It is enacted by the enactment of the 14th Amendment. Its disqualification where triggered just is. It follows that Section 3's disqualification may and should be followed and carried out by all whose duties are affected by it. On and on and on. All right, let's go to the third defense that they want to give for their position. Section 3 supersedes or satisfies earlier enacted constitutional provisions to the extent of any supposed conflict between them. Section 3, at the time it was adopted as part of the Constitution, imposed a disqualification from office based on an individual's past conduct. Even if imposition of such a disability might otherwise, if done by statute, have been a forbidden ex post facto law or bill of attainder, Section 3 of the 14th Amendment supersedes any prior provisions conflicting with its terms. And they say that because there were several congressional acts that removed the disqualification for some folks after the Civil War. They're saying, despite Congress removing that disqualification for those folks, that removal by Congress do not apply today. Congress would have to do it again today by a 2/3 vote of Congress. All right. What happened back then does not just automatically apply here. Again, that's why they use the term ex post facto law or bill of attainder. And the fourth part, the fourth defense that they offer, Section 3's disqualification is sweeping in its terms. It disqualifies from future office holding persons who engaged in an expansive and encompassing term connoting many forms of participation in or active support of a broad swath of activity covered by the terms insurrection or rebellion or giving or aid or comfort to enemies of the nation or its constitutional order. It applies to a broad swath of civilian, military, legislative office holders who swore oaths of fidelity to the Constitution, and it disqualifies such persons from holding in the future any of an extraordinarily broad swath of public offices. So they're basically saying that the terms of Section 3 of the 14th Amendment are very broad, and they cover a wide range of activities and a wide range of people. And certainly what we saw with our own eyes, heard with our ears, that Trump did to bring about that insurrection would definitely be covered by the broad language in Section 3 of the 14th Amendment. This law review article is long. It's 126 pages. They don't just make conclusory statements and hope you believe. These are two constitutional law professors, so they really explain this. I read it from cover to cover. As an attorney, I understood every word of it, and I agree with every word of it. There is the article also in The Atlantic that was co-authored by former federal judge J. Michael Luddick and current Harvard professor Lawrence Tribe. Now, both of these men are supporters of the GOP. And here's what they start out saying. As students of the United States Constitution for many decades, one of us as a U.S. Court of Appeals judge, that is the court that is just under the U.S. Supreme Court. We got the federal district courts, then we got the U.S. Courts of Appeals, then we have the United States Supreme Court. So he sat on a court that was just under the U.S. Supreme Court. All right, he said, one of us as a U.S. Court of Appeals judge, the other as a professor of constitutional law, and both as constitutional advocates, scholars, and practitioners, we long ago came to the conclusion that the 14th Amendment, the amendment ratified in 1868, that represents our nation's second founding in a new birth of freedom contains within it a protection against the dissolution of the republic by a treasonous president. It doesn't get any stronger than that. Let me increase it. I want to read that again. As students of the United States Constitution for many decades, one of us as a U.S. Court of Appeals judge, the other as a professor of con law, and both as constitutional advocates, scholars, and practitioners, we long ago, didn't just come to this, we long ago came to the conclusion that the 14th Amendment, the amendment ratified in 1865 that represents our nation's second founding and new birth of freedom, contains within it a protection against the dissolution of the republic by a treasonous president. They go on to say, this protection embodied in the amendment's often overlooked Section 3 automatically excludes from future office and position of power in the United States government, and also from any equivalent office and position of power in the sovereign states and their subdivisions, any person who has taken oath to support and defend our Constitution and thereafter rebels against that sacred charter, either through overt insurrection or by giving aid or comfort to the Constitution's enemies. The historically unprecedented federal and state indictments of former President Donald Trump have prompted many to ask whether his conviction pursuant to any or all of these indictments would be either necessary or sufficient to deny him the office of the presidency in 2024. Last paragraph that I read. Having thought long and deeply about the text, history, and purpose of the 14th Amendment's disqualification clause for much of our professional careers, both of us concluded some years ago that, in fact, a conviction would be beside the point. In other words, it's not needed. A conviction in court is not needed. They go on to say the disqualification clause operates independently of any such criminal proceedings, and indeed also independently of impeachment proceedings and of congressional legislation. The clause was designed to operate directly and immediately upon those who betray their oaths to the Constitution, whether by taking up arms to overturn our government or by waging war on our government by attempting to overturn a presidential election through a bloodless coup. There it is. Two very conservative, card-carrying members of the GOP, of the Republican Party, calling what Trump did an attempted bloodless, well, there was blood here. Blood was shed. Many people were unfortunately killed or died. Others were assaulted and so forth. I think every true patriot, every person who truly loves this country would have to agree that Trump cannot ever again take office. And it is so wonderful that we have a provision in the Constitution that prohibits him from becoming president. So think about it. When he raises, if he were to win in 2024 and were to become president and raise his hand to defend the United States Constitution against all enemies, both foreign and domestic, we couldn't take that serious. It makes no sense. And it's just so wonderful that there is a provision in the Constitution to prevent it. And there are people, even in his party, that are courageous and principled enough to take a stand for the truth. I so appreciate that. Okay? That's going to do it for me. I'm sure there's going to be a lot of debate about this law review article and Judge Luddick and Professor Tribe's article here. A lot of debate, a lot of back and forth, and so on. Trump and his followers are going to take this on, no question. There are going to be a lot of people who watch my video, and they're going to come for me. They're going to make all kinds of comments, whatever. The Constitution is clear. Here's some things that are clear. It's clear what Trump did. It's clear that he's a danger to this country. And it's clear what the Constitution says about a person who does this. All that's clear. So, out of my love for our country, I take the position I take. Again, I am Attorney Augustus Corbett. You're listening to the Defiant Lawyers. If you're not a subscriber, please subscribe. Also like, share, and comment. And until the next time, peace. Bye.
That Corbett and Corbett legal team fighting for the rights of the people. That father-daughter team investing in the youth when the system ain't treating them equal. Providing truth for our people, we able to reach them. So anytime you get accused for a crime and Lord knows you ain't do it, we here to get you through it. Exemplifying prudence and glorifying God, making sure you're compensated for other people's doings. Our vision is to be one of the best. We're small enough to focus on your matter throughout the neighborhoods of Dallas. Working constantly and making sure your rights are protected. A firm team of lawyers, aggressive, effective. A team that has your back in the courtroom. Two well-spoken black lawyers in the courtroom. Investing time and resources when it's evident that you were treated wrong. Now you walking out of Dallas courtroom with a settlement. Corbett and Corbett, the father-daughter legal tag team that has your back in the courtroom. Our purpose is simple. To obtain a favorable outcome for each client and glorify Christ in all we do. Our vision is to be one of the best and most